Okay, so let's start with History of Capital Market and Service Act 2007. Capital Market and Securities Act is formed by repeal the Securities Act 1983 and Future Industry Act 1993. It is take effect on 28 September 2007, introduced a single licensing regime for capital market intermediaries. Okay, next, function of CMSA 2007. It is to ensure a reasonable, practicable, and order manner and fair market in the securities that are traded through its facilities. It is also act in the public interest and ensure that where the interest that is required to serve under any law relating to corporations conflict with the interest of public. Next, it is ensure that the members at the stock exchange, also companies and corporations whose securities are listed on the stock exchange with the rules of stock. This act consists of 13 parts. Okay, so let's start with History of Capital Market and Service Act 2007. Capital Market and Securities Act is formed by repeal the Securities Act 1983 and Future Industry Act 1993. It is take effect on 28 September 2007, introduced a single licensing regime for capital market intermediaries. Okay, next, function of CMSA 2007. It is to ensure a reasonable, practicable, and order manner and fair market in the securities that are traded through its facilities. It is also act in the public interest and ensure that where the interest that is required to serve under any law relating to corporations conflict with the interest of public. Next, it is ensure that the members at the stock exchange, also companies and corporations whose securities are listed on the stock exchange with the rules of stock. This act consists of 13 parts. For the part 2, it is called Securities and Derivatives Market. It has two divisions, which is the first division is called Market. It is establishment of stock market or derivatives. The minister may establish by declare a particular stock market or derivatives market or stock market or derivatives market included in a particular class of stock market or derivatives market to be an exempt stock market or exempt derivative market for the purpose of this act, subject to such terms and conditions as he thinks reasonable and appropriate after having regards to, among other things, such as the type of securities or derivatives traded or to be traded, participant, investor, and the volume of trading. For the second division, which is market institution, it consists of subdivision 1, which is exchange and exchange holding company. For the subdivision 2, which is exchange holding company, and subdivision 3, which is general, subdivision 4, registered facilities, subdivision 5, approval of clearinghouse, subdivision 6, which is modification to the law of insolvency and miscellaneous provision relating to the operating and procedures relating to the operation and procedures of approved clearinghouse. Okay, now we move to the part 3, which is capital market service. It has three divisions. Okay, the first one is licensing and regulating. First, it is requirement for capital market service license. Okay, no person shall, whether as a principal or agent, carry on a business in any regulated activity or hold himself out as carrying on such business unless he is the holder of a capital market service license or is a registered person. Any person who contravenes subsection commits an offence and shall, on conviction, be liable to a fine not exceeding 10 million ringgit or to imprisonment for a term not exceeding 10 years or to both. Second, it is requirement for capital market service representatives license. Okay, no person shall act as a representative in respect of any regulated activity or hold himself out as doing so unless he is the holder of a capital market service representative license for that regulated activity or is a registered person with respect to that regulated activity. Okay, the last one is it is application for grant of license. It is shall be made to the Commission in such form and manner as the Commission may specify. Okay, now we move to Division 2, which is records. It is application of this division applies to a person who is, first, a licensed person who carries on the business of dealing in securities. Second, a licensed person who carries on the business of fund management. Third, a licensed person who carries on the business of advising on corporate finance. Fourth, a licensed person who carries on the business of investment advice. Fifth, a licensed person who carries on the business of financial planning. Sixth, a financial journalist. And lastly, an authorized depository agent appointed under Section 13 of Security Industry Central Depositories Act 1991. Okay, now we move to the last division, which is books, clients, assets, protection. Okay, the first one is books. A holder of a capital market service license shall maintain or cause to be maintained in the national language or English language such accounting records and other books as will sufficiently explain the transactions and financial position of its business and enable true and fair profit and loss accounts and balance sheets to be prepared from time to time. Okay, second, treatment of clients' asset in respect of securities. Okay, a certain monies received by holder of capital market service license to be paid into trust account. Okay, clients' asset other than monies received by holder of capital market service. Third, withdrawal of money from trust account. Third, holder of capital market services license to supply copies of entries in books. And lastly, it is claim and liens not affected.
Next is Capital Market Compensation Fund. For Division 1, which is the Capital Market Compensation Fund Corporation, there are 3 points in it, which are the corporation, functions of the corporation, also duties and responsibilities of the corporation. For the corporation, a body, corporate known as the Capital Market Compensation Fund Corporation, is established, while for the functions of the corporation is the corporation shall manage and administer the Capital Market Compensation Fund and process and handle claims for compensation under this part. And lastly, for duties and responsibilities of the corporation is the corporation shall exercise its power in good faith in accordance with the provisions of this Act and comply with any direction or guidelines issued by the Commission. Next is for Division 2 is Capital Market Compensation Fund. Establishment of the Capital Market Compensation Fund have 2 components, which are a fund to be known as the Capital Market Compensation Fund is established, which shall be administered by the corporation. The corporation shall hold the assets of the Capital Market Compensation Fund in trust for the purposes as provided under this part. And for Division 3, provision relating to claims. So there are a few rules of the corporation, which are the corporation shall make rules to be approved by the Commission governing the proper administration of the corporation and the Capital Market Compensation Fund, and the corporation shall not amend its rule without the prior approval of the Commission. In this part 5, I will explain about market misconduct and other prohibited conduct. In this part, there are 2 divisions, which are prohibited conduct securities and prohibited conduct derivatives. So now I will explain the Division 1 first, which are prohibited conduct securities. There are 3 subdivisions in it. Firstly, offences relating to false trading and market rigging. First one, false trading and market rigging transaction. Subject to Section 180, no person shall create or cause to be created or do anything that is calculated to create a false or misleading appearance of active trading in any securities on a stock market within Malaysia, or a false or misleading appearance with respect to the market for or the price of any such securities. A person shall not by means of purchases or sales of any securities that do not involve a change in the beneficial ownership of those securities or by any fictitious transaction or device maintain, inflate, depress or cause fluctuation in the market price or any securities. Next is subdivision 2, which is insider trading. In this part, we have information generally available. For the purposes of this subdivision, information is generally available if the information has been made known in a manner that would tend to bring it to the attention of reasonable persons who invest in securities of a kind whose price or value might be affected by the information, and since it was so made known, a reasonable period for it to be disseminated among and assimilated by such person as elapsed. Next is subdivision 3, is civil remedies. There are two civils in it. Firstly, civil liability for contravention of section 175, 176, 177, 178, 179 and 181, where a person who suffer loss or damage by reason of or by relying on the conduct of another person who has contravened may recover the amount of loss or damage by instituting civil proceedings against the other person, whether or not the other person has been charged with an offence in respect of the contravention or whether or not contravention has been proved in a prosecution. For division 2 is derivatives prohibited conduct. In this division, there are two subdivisions in it. Firstly, for division 1 is offences conduct to false trading bucketing. There are two components in it. Firstly, false trading. No person shall create or cause to be created or do anything that is calculated to create a false or misleading appearance of active trading in derivatives on a derivatives market or a false or misleading appearance with respect to the market or the price of trading in derivatives on or on the derivatives market. Secondly is bucketing. No person shall execute or hold himself out as having execute an order for the purchase or sale of derivatives on a derivatives market without having effected a purchase or a sale of the derivatives in accordance with the rules and practices of the derivatives market. Next is subdivision 2 is civil remedies. There are two civil in it. Firstly, civil liability for contravention of section 202, 203, 204, 205 and 208. A person who suffers loss or damage by reason of or by relying on the conduct of another person who has contravened may recover the amount by loss or damage by instituting civil proceedings against the other person, whether or not the other person has been charged with an offence in respect of the contravention or whether or not a contravention has been proved in a prosecution. Secondly is civil action by commission, where it appears the commission that any person has contravened, the commission may institute a civil proceeding in the court against that person, whether or not such person has been charged with an offence with respect of contravention or whether or not a contravention has been proved in the prosecution. The commission may, if it considers that it is in the public interest to do so, by civil action against such person in contravention. There are 2 points which are recover an amount which shall not exceed 3 times the gross amount of the pecuniary gain made or loss avoided by such person and claim civil penalty in such amount as the court considers appropriate having regard to the seriousness of the contravention being an amount not more than 1 million ringgit.
Part C, Issues of Securities and Takeover and Merger. Division 1, Listed and Unlisted Capital Market Product. Requirement for approval, registration, authorization or recognition. This part does not apply to a private retirement scheme. A person who proposes to undertake a proposal, scheme, transaction, an arrangement or activity or issue securities or offer for subscription or purchase of securities or issue an invitation to subscribe for purchase securities in relation to A. The listing and quotation of securities of a corporation on a stock market. B. The transfer of a listing and quotation of securities of a corporation from an alternative market to the main market. C. The listing or quotation of securities other than securities in paragraph A, including units of a business trust or Islamic securities on a stock market. And D, an acquisition or disposal of asset which result in a significant change in the business direction or policy of a listed corporation, listed unit trust scheme, or any other listed entity, whether not in relation to any proposal, scheme, transaction, arrangement, or activity. Division 2, Takeover, Merger and Compulsory Acquisition. Mention Code on Takeovers and Mergers. The Minister may, from time to time, on the recommendation of the Commission, amend any of the provision of the Code, and any amendment thereto shall be published in the Gazette. The Code shall contain principles and rules governing the conduct of all persons or parties involved in a takeover offer, merger or compulsory acquisition, including an acquirer, offerer, offeree and their officials and associates. Actions by Commission in cases of non-compliance with Code and rulings. Where the person in breach is a listed corporation, direct the stock exchange, first, to suspend trading in the securities of the corporation, second, to suspend the listing of the corporation, or third, to remove from the official list of the corporation or the class of securities of the corporation. Division 3 is prospectus. Requirement to register prospectus in relation to securities. A person shall not issue, offer or subscription or purchase, make an invitation to subscribe for or purchase securities, or in the case of an initial listing of securities, make an application for the quotation of the securities on a stock market of a stock exchange unless a prospectus in relation to the securities has been registered by the Commission under Section 233. Second, the prospectus complies with the requirement of provision of this Act. Registration of prospectus. The Commission shall refuse to register a prospectus if the Commission is not the opinion that the prospectus does not comply with any provision of this Act. Second, the issue of offer for subscription or purchase of or invitation to subscribe for purchase securities to which the prospectus relate does not comply with any other requirement or provision of this Act. And third, the Commission of the opinion that the prospectus contains any statement or information that is false or misleading, or that the prospectus contains any statement or information from which there is a material omission. Division 4 is debentures. For the subdivision 1, trust deeds, duties of trustees borrower. Requirement for trust deeds and trustee. Every person issuing, offering for subscription or purchasing, or making an invitation to subscribe for any purchase, any debentures shall enter into a trust deed that meets the requirement of Section 259. Appoint a trustee who is a person eligible to be appointed to act as a trustee in accordance with Section 260 and comply with the requirements and provision of this division. Persons who can be trustees. A trustee shall be a company registered as a trust company under the Trust Companies Act 1949, or a corporation that is a public company under the Companies Act 1965, or under the laws of any other country which has been approved by the Commission to act as trustee for the purpose of this Act. Duties of the borrower. A borrower shall use its best endeavours to carry on and conduct its business in a proper and efficient manner, to provide a copy of the trust deeds to a debenture holder, a trustee, or any other person as may be allowed by the Commission, if they request a copy, and upon payment of such reasonable sum as may be imposed by the borrower. For the subdivision 2, it is general. Registered debentures holders. Every borrower which issues debentures, not being debentures transferable by delivery, shall keep a register of debenture holders at its registered office or at some other place in Malaysia. Division 5. Unit Trust Scheme and Prescribed Investment Scheme. Requirement for trustee and deeds. Subject to subsection, every person issuing, offering for subscription or purchase, or making an invitation to subscribe for purchase any unit shall first ensure that trustee who has been approved by the Commission under Section 298 and who is eligible to be appointed to act as trustee under Section 290 has been appointed. Second, enter into a deed that has been registered under Section 293 and that meets with the requirement of Section 294, or ensure that there are in force a deed that has been registered under Section 293 and that meets with the requirement of Section 294. And lastly, comply with the requirements and provision of this Act. Division 6, Islamic Securities. Prescription by Minister in respect of Islamic securities. This division applies to a person who proposes to make available, offer for subscription or purchase, or issue in an invitation to subscribe for a purchase or Islamic securities. Where the Minister has made the prescription under Section 5 in respect of Islamic securities, the Minister may make such modifications in the perceptions on the usage of expressions in the securities laws as may be necessary to give full effect of the principles of Sharia in respect of such Islamic securities. Part 7. Provision applicable to listed corporation. Duty of Chief Executive and Directors of List Corporation to disclose interest in securities. Second, disqualification of Chief Executive or Director of listed corporations. Third, submission of information. Fourth, duty of auditor of listed corporations. Fifth, false or misleading financial statements of a listed corporation. And lastly, protection for persons against retaliation for reporting to authorities in specific circumstances. Part 8. Self-regulatory organization. Recognition of self-regulatory organization. The Commission may, with the concurrence of the Minister, where it thinks appropriate in the public interest or for the protection of investors by notice published in the Gazette, declare a person to be recognized self-regulatory organization subject to such terms and conditions as the Commission thinks fit if it is satisfied that first, the person in discharging its obligation under Section 3 to 4 will not act contrary to the public interest and in particular the interest of investors. Second, the person shall be able to take appropriate actions against its members and any person to whom the rules apply to. Third, the person has sufficient financial, human and other resources to carry out its function. The person is fit and proper and satisfied with the criteria or standards referred to in Section 64 or any rules of the stock exchange or derivative exchange. As the case may be, the person is managed by officials who are fit and proper and who satisfy the criteria or standards referred to in Section 65 or any rules of the stock exchange or derivative exchange or any applicable guidelines. As the case may be, the person has competent personnel for the carrying out of its function. And lastly, the rules of the person make satisfactory provision.
So next part is Capital Market Development Fund, which is assets constituting fund. So the fund shall consist of such shares as are approved for the fund under paragraph 4(1)(d) of the Demutualization Kuala Lumpur Stock Exchange Act 2003, and then proceeds raised in connection with the sale of the shares that are referred to in paragraph A, and such sums as may be provided from time to time for the purposes of this part of by the Parliament. The next one is all donations and gifts accepted by the board for the fund. All interest, dividend and other income derived from the investment of the monies of the fund. And lastly, all other sums or property which may in any manner become payable to or vested in the fund. So the next part is disclosure information. So there are two subdivisions, which is 1 and 2. So subdivision 1 is application. Application of this part, the Commission shall seek the assistance of Bank Negara where it appears to the Commission that it is necessary to examine the books of a licensed institution or maybe Islamic bank other than a licensed institution that holds a capital market services license, and then relating to the affairs of a customer of the licensed institution or Islamic bank for the purpose of investigating the affairs of the customer. So next subdivision is disclose of information. So the Commission may require a holder of a capital market services license who carries on the business of dealing in securities in order to disclose to the Commission in relation to any acquisition or disposal of securities. So any information, including the name of the person from or through whom or on whose behalf the securities that were acquired, or through whom or on whose behalf the securities that were disposed of, and the nature of the instructions given such holder in respect of acquisition or disposal. So next part is offences. A person who contravenes a requirement made under section 348 commits an offence and shall, on conviction, be liable to a fine not exceeding 1 million ringgit or to imprisonment for a term that not exceeding 10 years or to both. So next part is administrative and civil action. Powers of commission to take action. Where a person contravenes the provisions of this act or any securities laws or fails to comply with, observe, enforce or give effect to the first one, the rules of a stock exchange, approved clearing house or central depository. Second one, any written notice, guidelines issued or condition imposed by the commission. Or the third one, any rule of a recognized self-regulatory organization in circumstances where the person is under an obligation to comply with, observe, enforce or give effect to such rules, written notice, guidelines or conditions that a person has committed a breach. The second one is, if a person has committed a breach and the commission is satisfied that it is appropriate in all the circumstances to take action against that person, the commission may take any one of more of the following actions, which is the first one is to suspend trading on the derivative market in a particular class of derivative. The second one is to limit transactions on the derivative market to the closing out of derivative. The third one is to defer for a stated period the completion date for all derivative or for a particular class of derivative entered into on the derivative market.
Assalamualaikum warahmatullahi wabarakatuh. My name is Wan Ahmad Azri Zaldane bin Wan Ahmad Azman. My student ID is 20204767. And for my part, I will present about general, which is prohibition of use of certain titles on part 12. A person who is not a participating organization or an affiliate shall not take or use or by inference adopt the name, title or description of participating organization or affiliate, or take or use or having attached to or exhibited at any place any name, title or description implying or tending to create the belief that such person is a participating organization or an affiliate. Next slide, I will present about part 13, which is repeal saving and transitional provision. The first one is repeal of Securities Industry Act 1983 and Futures Industry Act 1993, and savings and transitional in respect thereof. Repeal Acts means the Securities Industry Act 1983 and the Futures Industry Act 1993, so repealed under this part. Then, the Securities Industries Act 1983 and the Futures Industry Act 1993 are repealed with effect from the effective date. So, the second one is transitional and savings in respect of corporate proposals. Without prejudice to the generality of Section 381, all actions, rules, regulations, order, directions, notifications, approvals, decisions, and other executive acts, howsoever called, made, given, or done under, or in accordance with, or by virtue of Section 2B and Part 4 of the Securities Commission Act 1993, before the effective date shall, insofar as it is consistent with the provisions of this Act, be deemed to have been made, given, or done under, or in accordance with, or by virtue of the corresponding provision of this Act, and also shall continue to remain in force and have effect in relation to the persons, activities, or transactions to whom they apply until amended, revoked, or rescinded under, in accordance with, or by virtue of the corresponding provisions in this Act. So, the next slide, I also will present about transitional provision for corporate finance, executive and research analyst. Transitional provision for corporate finance, which is executive, is who is employed by a stockbroking company and who is registered with the commission pursuant to the commission's guidelines for dealers and dealers representative under the Repealed Securities Industry Act 1983. A research analyst is who is employed by a stockbroking company and who is registered with the commission pursuant to the commission's guidelines for the dealers and dealers representative under the Repealed Securities Industry Act 1983. So, the next slide, which is the cases. The first cases is regulatory settlement with Tamkin Court. On 8 August 2014, the SC entered into a settlement with Tamkin Court in the sum of 5,095.72 when he agreed without admission or denial of liability to settle a claim that the SC was proposing to institute against him for insider trading in the shares of WCT Berhad between 30 December 2008 and 2 January 2009, contrary to Section 188(2) of the Capital Markets and Services Act 2007 CMSA. Then, the settlement was reached following a letter of demand sent by the SC pursuant to its civil enforcement powers under the securities law, where the sum Tam was required to disgorge was equivalent to 3 times the difference between the price at which the shares were disposed and the price at which they would have been likely to have been disposed of at the time of the disposal, if the information had been generally available in accordance with Section 201(7) of the CMSA. The amount recovered from Tam will be used first to reimburse the SC for all costs of investigations and proceedings. Then any remaining amount, if available, will be used to compensate the buyers who bought their WCT Berhad shares before the information will become generally available. Next slide, I will present about the second cases, which is regulatory settlement with Muhammad Irtiza Azmil bin Muhammad Ismail and Muhammad Ismail bin Yahya. On 11 August 2014, the SC entered into a settlement with Muhammad Irtiza Azmil bin Muhammad Ismail and also Muhammad Ismail bin Yahya in the sum of 22,000 when they agreed without admission or denial of liability to settle a claim that the SC was proposing to institute against them for insider trading in the shares of Bousted Properties Berhad, which is on 14 May 2008, contrary to Section 188(2) of the Capital Markets and Services Act 2007, which is CMSA. Then, the settlement was reached following letters of demand sent by the SC person to its civil enforcement powers under the securities laws, where the sums both of them were required to disgorge was equivalent to 3 times the difference between the price at which the shares were acquired and the price at which they would have been likely to have been acquired at the time of the acquisition, if the information had been generally available. Next, in accordance with the provision of Section 201(7) of the CMSA, the amount recovered from them will be used first to reimburse the SC for all costs and investigation also proceedings. That's all from my group, and thank you for watching and listening. That's all. Thank you, and Assalamualaikum warahmatullahi wabarakatuh.